express the court's appreciation to counsel for being able to appear early. We appreciate that. Next case is State versus Burris, and we will hear from the appellant.
Chief Justice Newby and Honorable Justices, good afternoon. May it please the court, my name is Kim Hoppin, and I represent Kyle Allen Burris in this matter. We're here today to talk about whether the majority opinion and to what extent the majority opinion and Mitchell v. Wisconsin's holding dispense with the protections of the Fourth Amendment in warrantless blood draws, and whether the almost always finding in that Mitchell opinion effectively creates a per se exception to the warrant requirement. The dissent in this case, upon which this appeal is based, is suggesting that the majority's holding forgoes any considering of exigent circumstances on a case-by-case basis or fact-specific basis or under the totality of circumstances, which is how generally these things are considered. The dissent in this case agreed with the majority that the lay opinion testimony offered by the trooper in this matter regarding the fact that Mr. Burris was the driver, or describing how this accident occurred, which he did not observe, and he was not an accident reconstruction expert. He agreed that with the majority, who also found that this was error to admit this testimony, but both the majority and the dissent also agreed that any error was cured by the limiting instruction. So we can sort of set that aside for now. I also I neglected to say that I'd like to reserve at least 5 minutes for a rebuttal at the end of I don't think we'll get there, but the primary issue that the dissent has in this matter is that the Fourth Amendment requires that judgment calls are to be made by a neutral and detached magistrate and not by the officer engaged in it's quoted, the often competitive enterprise of ferreting out a crime, and where the majority's holding following Mitchell v. Wisconsin defines exigent circumstances as any time you have an unconscious driver that has to be taken to the hospital, and they conclude that this almost always creates the necessary exigent circumstances to forego the warrant requirement. The dissent argues that that takes the judgment call out of the hands of the neutral, detached magistrate and puts it into the officer's hands. In this case, we do have an unconscious defendant who was taken to the hospital, yet there still is a fact-specific case-by-case analysis to be done here, because even the majority and Mitchell leave room for the fact that although almost always this creates exigent circumstances, it does not always create it, and that still leaves the analysis to be done. Here you have an accident that occurred, but no one knows when it occurred or exactly how it occurred. There's no evidence about whether there were any other vehicles. There certainly weren't other vehicles involved in the crash scene, but that doesn't mean that there weren't other vehicles there. There's no evidence to suggest how long the accident had occurred when the trooper arrived on the scene. There's no evidence to suggest who called the accident in.
Did the Court of Appeals have to follow the rationale in Mitchell, given that Mitchell is a plurality decision?
I think they do have to follow that rationale. I think they can consider it. You know, we're talking about a federal constitutional principle here, so I do believe that they have to follow that plurality opinion. That would be my answer to that.
Well, and part of it, Justice Thomas, his proposed holding would be even further than the 4 justices in the plurality, right? Because
Yes,
he would
that-
say, if there's a need, if there's some urgent need, that alone would be enough to create an exigency under the Fourth Amendment.
Yes,
That was
and-
what I understood Justice Thomas.
And I think he would have considered the implied consent issue, which the plurality did not address. What's interesting about the Mitchell holding is that neither party even raised the issue of exigent circumstances in any of the prior briefings before the Supreme Court. And in fact, according to the opinion, Wisconsin had even waived that as an issue and said that exigent circumstances did not apply. Nevertheless, we have the holding we have.
Which does say that almost always can do it. I take it, your position is, this is one of those cases in the almost always is not always.
Right. That would be my position. And I think that what the dissent is arguing is that under our precedent, the Fourth Amendment is not a mere formality, that the warrant requirement is important, that a blood draw is an intrusive search. The way it gets described is they're injecting a needle and withdrawing a piece of your person. But in addition, it can tell all kinds of things about you, not just your blood alcohol level. And so there are definitely competing interests here. And the formality, it's not just a mere formality. And so there needs to be still an evaluation. And if there's time to get a warrant, then the officer is required to do that. And under the circumstances of this case, there was time, I believe. And to the extent that there are these circumstances, there isn't evidence backing up. There was no medical testimony about what Mr. Burris was needing to undergo in terms of treatment. He certainly was injured. I believe the trooper in this case had some expertise as a paramedic, and so he could visibly observe injury. But injury alone is not what creates the exigency. It's the unconsciousness based on the Mitchell opinion that creates the exigency, because there is no way for him to consent. So, but in this case, as Judge Tyson pointed out in his dissent, the fact that he's about to go into surgery even does not alone create the exigent circumstances. The trooper explained that when he left the scene of the crime after spending, he said his testimony was 1 to 2 hours. And I would argue that there's a pretty significant difference between 1 hour and 2 hours when we're talking about this time period here, that he was equidistant from the hospital and the courthouse. And one of the reasons he gives for not going to get a warrant is that he doesn't know whether the magistrate will be available or whether he'll be busy or will there be a line. But that's going to be the case under every single circumstance. If that in fact creates a reason to call this exigent, then that would be true in every single case. The other point that I would like to make is, I believe the state contends that the dissent did not address the sufficiency argument concerning the reckless driving. And while Judge Tyson did not use the word sufficiency, he clearly discussed the fact that there was, in his opinion, insufficient evidence of reckless driving. Again, we have a situation where no one observed this accident. No one, so even if you find sufficient evidence of driving, there's not sufficient evidence of any reckless driving. And the fact of the accident alone does not create that sufficiency. I'd be happy to answer any additional questions. In an appeal like this, I'm bound by the argument made by the dissent here, and by the law as it stands.
Thank you, counsel. Hear from the appellee.
Hopefully I can balance this.
Good afternoon, and may it please the court. I am Derek Mertz, and I represent the state of North Carolina in this matter. There was no error, let alone plain error, in the trial court's concluding that exigent circumstances existed in this case to support the warrantless blood draw of the defendant at the hospital. While the dissent doesn't come out and say it, it seems to flow from its belief that Mitchell v. Wisconsin was wrongly decided, rather than that Mitchell does not apply to or is distinguishable from the instant facts. Disagreement with a binding Supreme Court decision is arguably not a proper basis for a dissent in our Court of Appeals in a case interpreting the Fourth Amendment of the United States Constitution. The dissent also ignores that, notwithstanding Mitchell, the Court of Appeals itself has several times over interpreted materially similar facts to support exigency. And that is the case even without considering unconsciousness as one of those factors. Like the dissent, the defendant does not attempt to distinguish Mitchell v. Wisconsin from the facts of this case. And it doesn't demonstrate any error in the majority's application of it. And for those reasons, this court should affirm. The factors supporting exigency in this case were numerous. The defendant was in a serious accident. He had significant facial, chest, and arm injuries. He was losing blood. He was unconscious. His condition was critical. It required EMS treatment on scene, where a defendant was treated for over an hour before he was transported. And he had to be transported by life flight, and they had to secure a landing zone in order to do that. And all throughout this time period, that scene needed to be secured and closed off to traffic. Trooper Lancaster was the responding officer. He was an accident investigator, and he was also responsible for all the attendant duties of investigating that accident. He was also responsible for waiting for the tow truck so that he could open the road back up and clear the scene so that traffic could travel down that roadway. From that point, he went directly to the hospital in order to do a follow-up investigation and see where defendant's condition stood. And we know, although the testimony was that he was on scene for 1 to 2 hours, we know precisely how long it took him from the time he arrived at the scene to the time he at least requested blood, he got to the hospital. It says that he arrived at the scene at 8:41, and as counsel notes, we have no idea how long that accident, how long it had been since the accident occurred, or how long it had been since the defendant was lying on the roadway. We do know that before the trooper arrived, there was enough time for other emergency personnel to get there. So from 8:41 to 11:10, which is when he got to the hospital, approximately 2 hours and 30 minutes had elapsed, and the blood draw was requested or recorded on the sheet at 11:15. The defendant at this point was still unconscious and unable to perform any breath test, and despite that, the officer in this case read the rights and consent form. The other factors contributing to exigency in this case include the natural disposition of alcohol. Absolutely, McNeely stands for the proposition that that factor alone is not per se exigent circumstances, but it doesn't mean that it's not an appropriate circumstance to consider, with all the other circumstances related to exigency. And we do know, again, that the delay had been at least 2.5 hours. We also have dilution by other means. We know that the defendant started receiving IV treatment in the roadside, so we know that he's been giving IV fluid for at least an hour, if not more so, while he's still bleeding and he's hooked up to machines at the hospital. Add to that, we've got that extrapolation already adds uncertainty, and that becomes less certain with time. So it's essentially, it gets worse, it compounds itself. We also know that going to get a warrant would take at least some additional time. We don't know precisely how long that would be. Assume it's 5 minutes down the road, it takes another 15 minutes. We're adding at least a half hour to the calculus. We also know that when and if he went to go get a warrant, had he come back, there's no telling whether or not he could even secure blood at that time. Defendant was headed towards surgery. We just don't know how long that surgery would have taken. We don't know if the delay would have been added, whether there had been further dilution, or whether that blood sample would have been contaminated by medical treatment during surgery. On those factors and others, there was overwhelming evidence of exigent circumstances, even without Mitchell v. Wisconsin. However, Mitchell v. Wisconsin adopted the rule that there is almost always going to be exigent circumstances on that bare factor, on a single factor, unconsciousness alone. And the reason it decided that is because unconsciousness itself is a medical emergency. Because of that, the driver is likely to be transported to the ER. The blood is going to be likely drawn by the hospital anyway. Unconsciousness is often due to accident, which it was in this case, and in those scenarios, an officer's responsibilities are going to be split between securing evidence for a potential crime, but also attending to those other duties in terms of investigating the accident, securing the scene, all those things. Mitchell did not say that those things needed to be present, and in fact, in Mitchell itself, there was no accident. We don't have serious injury in Mitchell. What we have in Mitchell is a case where the officer actually had time to drive that defendant to the station and was preparing to administer a breath test when the defendant became lethargic. So unlike this case where the defendant was unconscious throughout for almost 3 hours, you have defendant in Mitchell who at least was conscious for a period of time and was able to be transported to the police station. Even with that fact, the court didn't hold it was unreasonable for the officer to then, when the defendant in Mitchell became lethargic, to take him to the hospital, and although he had been right there with the magistrate, to then demand a blood sample at the hospital when he got there. The arguments that defendant and the dissent bring up are without merit. Defendant argues that he was not seriously injured, and therefore there weren't exigent circumstances. Under Mitchell, that does not matter. But defendant was ejected from a car at 60 miles an hour and had serious, significant injuries. He was in critical condition. He had lost lots of blood, and he was unconscious throughout. The dissent, in contrast, argues that the defendant was actually too injured for there to be exigent circumstances because it was likely he was going to die anyway. That also doesn't matter, but that actually reinforces the reasonableness of the officer attending to his duties on the scene to make sure that he crossed every T and dotted every I during his investigation report, which could possibly have been a fatality. The dissent and the defendant argue that the blood would have been drawn anyway, but again, that doesn't matter. Mitchell resolves that against them, and it actually determines that that factor adds to the reasonableness of a blood draw. Both also argue that it was reasonable for us to drive to the magistrate. But there was nothing unreasonable in what the officer did here. There was nothing improper about him going to check on the defendant's condition to see whether or not, one, a blood draw would have been necessary to begin with, or two, whether he would have been awake and improving and able to consent to a request. But the question under the Fourth Amendment is not whether there are other reasonable courses of action that the officer could have taken. The question is whether the officer reasonably believed that he was confronted with exigent circumstances which any delay to get a warrant threatened the destruction of the blood alcohol evidence in this case. And here, those facts are overwhelming to support both the trial court's order and the majority's decision. There are two other matters I'd like to address briefly. You know, there's been some concern whether or not the Supreme Court shifted the burden to the state to shifted the burden to the defendant to produce evidence. I don't think that's actually what that language in the Mitchell decision means. I think there's one of two appropriate interpretations of the court's language. Neither of it shifts the state's initial burden to the defendant to produce evidence, and both are permissible under the jurisprudence of the Fourth Amendment. The first is that, you know, was the court creating a presumption whereby if the state meets its burden to show simply unconsciousness, whether now the burden has shifted to the defendant to show his is the unusual case. The second is that the state generally meets the burden by showing unconsciousness and was simply inartfully remanding the case to allow the defendant to address this new rule that the court had created because it had not been decided or argued in any case previously, and the parties in this case did not have the opportunity to address this new rule. And that is typically, I believe that's what the court was doing. That typically is what occurs in U.S. Supreme Court jurisprudence. You essentially get the benefit of any new rule that is created, and they were just affording the court that, affording the defendant that opportunity. In terms of what might be meant by the almost always language, Justice Dietz, I think what we're talking about here is, it's obviously not the circumstances of this case. The unconsciousness in this was to a much greater degree than even in Mitchell. But one might imagine there's a case out there where unconsciousness alone would not provide exigency. And one of those circumstances that I've thought about is, you know, what if the officer gets to the scene, the defendant's been unconscious, 5 minutes passes, defendant wakes up, he's actually cleared by medical personnel, we're 10 minutes into the traffic investigation. Under circumstances such as that, there may be, you know, there's potentially a good argument that unconsciousness alone shouldn't give exigency in those circumstances. What if the defendant falls asleep and is woken up and the officer thought he was unconscious, but he wasn't actually unconscious? Perhaps that too might be some type of circumstance. But you already have a circumstance where the defendant isn't unconscious throughout the investigation, and that's Mitchell. We know that for a good bit of that initial investigation, the defendant was not unconscious, and he wasn't unconscious until he had gotten to the station and became lethargic, and then ultimately remained conscious but lethargic until he was put into the patrol car, and it was only when he was being driven to the hospital. So we know that degree of unconsciousness seems to give rise to this categorical rule of almost always providing exigency.
And your main point is the search here is much more reasonable than the one in Mitchell. So whatever the almost always carves out some exception, it wouldn't make sense for this case to be in it because it's far more reasonable under the circumstances than what the court said there.
Correct. You know, the court discusses in Mitchell that spectrum of exigency, and this falls even outside the Mitchell case. I mean, if Schmerber is sort of that, you know, one of the things that the court did is address the Schmerber facts and hold that those provide reaffirmed essentially that those would very likely provide exigency. Now, those are not the facts of Mitchell, but so we know that on the exigent spectrum, the very lowest is McNeely, which is it's a totally routine traffic stop, and there's no accident, there's no injury, there's none of these other things that are going on in this case. And then we have Schmerber, where there's not even where there's not even unconsciousness, but there's an accident. That would be sufficient because of the duties. And then we have Mitchell, where there's unconsciousness alone, that there hasn't been an accident. That would provide exigency. So certainly, when you have an accident, you have serious injuries, you've got unconsciousness throughout, it would seem that these set of circumstances far exceed the spectrum that's even being discussed in the Mitchell decision. To your question, Justice Allen, you asked whether or not the Court of Appeals is bound by a plurality opinion. Absolutely, as Justice Dietz pointed out, you know, the plurality opinion is the most limited holding that you can draw from the 5 justices. And because Justice Thomas would go even further and hold essentially that there's a per se rule of exigency whenever we're dealing with DWI cases, that plurality opinion is absolutely binding and was binding on the court below. If there are no further questions, we would ask that you affirm the majority decision.
Thank you, counsel. Rebuttal.
Just briefly, I would just like to address a point or two that the state made. I would contend that that Mr. Burris was not arguing that there was no injury or that he wasn't seriously injured. My argument is that there's not sufficient evidence or testimony from any medical professionals about what exactly his injuries were. I will point out about some of the circumstances of this scene that the trooper could not recall whether he had called for backup. He did not have to be the person transporting Mr. Burris to the hospital. There were a number of EMS, fire personnel to assist on the scene, and that is one circumstance that many of these cases discuss, that one officer can do the transportation of the defendant while another one goes to secure the search warrant. I will also note that the trooper, while he did have some training in accident reconstruction, he was not an accident investigator beyond his basic law enforcement training. He was not an expert, and he conceded that point during the hearing and trial.
What about, how do you respond to the basic argument that in this case, we have many more facts supporting the view that there were exigent circumstances than were present in Mitchell?
I mean, that's a problematic circumstance for me, arguing this case. I think, though, that the issue is that each case turns on its own set of facts, that you're looking at the totality of the circumstances. And one of the things that was concerning, I believe, to the dissent is that it's creating a situation where the officer is in control of a lot of these circumstances. And he's also the one who gets to make the determination of whether he has exigent circumstances or goes to seek a warrant. And the officer then has the ability to, manipulate is not the right word, but he has some control over the circumstances of the scene. And they're simply, I would just say that I think that you still have to, that under our Fourth Amendment jurisprudence, you look at each case by case, it's fact specific. Each particular DWI is going to have a different set of circumstances. But that is all. I would hope that the court would follow the dissent in this case and reverse the holding of the majority opinion and dismiss the two offenses. Thank you so much.
Thank you, counsel.
All rise.